It is time again for Legal Talk on eRadio, and last week we were talking about expired foods and what the law says about it. Today, a very, very hot topic. We'll be talking about residential and commercial tenants and not being able to pay rent, which is, of course, something we've seen over the past 2 years, especially because of the economic impact of the pandemic. So today we ask Jaco Hamman from Hahn Hahn Attorneys, what are their rights and what can be done and what cannot be done. But firstly, Jaco, hello and welcome. Tell us a bit more about yourself.
Jan, thank you. Yeah, similar to Janusz, who you met last week, I'm one of the partners at Hahn Hahn Attorneys, and I've been in practice now for approximately the last 17 odd years. I hold an LLB degree as well as a master's degree in forensic accounting, which means that I'm a practicing attorney as well as a practicing forensic accountant. And then in order to mediate and not just try and fight battles, I'm also a court annexed mediator for my sins. And I assist clients in the fields of commercial law, which of course encompasses contract law and labor law and forensic accounting and investigations, and then as well as construction and administrative law that I assist clients.
Okay, so Jaco, a very big topic that we're talking about today, residential and commercial tenants not being able to pay their rent or full rent because of the economic impact of the pandemic that kind of started in 2020. I mean, before then, even with the recession, people were, battling to pay their rent, and then the pandemic came along. Nobody saw that coming, and we ended up with quite a situation. But today, the question is, let's say you're a residential tenant or even a commercial tenant. What are your rights? What can landlords do and what can they not do?
Yeah, thank you. It's like you say, it's a very hot topic, and I throughout the pandemic and even now has had numerous clients, new and existing clients, came to me with the same question. Now, before I answer the question that the listeners have to ask themselves, there's two questions, and just to place everything sort of in perspective. And the one is, let's say a husband loses his job for whatever reason, whether that landlord is then obliged to provide the family with a rental rebate. So we say whatever the result, but let's forget about pandemic. Let's say it's in normal times. So now he loses his job. Can that family then demand that they stay for free in the landlord's house? And similarly, let's say a business isn't doing well because their sales are down. Whether then that tenant or the company is entitled to a rental rebate. In other words, does the tenant then not to have to pay the full rent just because his business isn't doing well? Now, the short answer, of course, to those questions is unfortunately no. So now, keeping that in mind, for specific to the pandemic and where we are at, in order to answer the question, there's a couple of things that we need to consider and look at. And first of all, the contract that either the residential or commercial tenant in the family or the business has with its landlord, or like we refer to it sometimes as the lessor. Now, a contract is a very funny thing. Contracts get signed, I want to say, by the millions each day, but very rarely people read the contract. And that is the most serious thing in the world. And the reason for that is that contract is the law basically between the two parties. Now, I've had family members coming to me and say, well, they want to do this and I must just give them a contract, but nothing is going to go wrong, so just draft something and then they'll sign it. And then I laugh and I say, well, if nothing is going to go wrong, shake hands and do what you want to do. Yeah. And the reason for that is that the purpose of a contract is to cater for when things go wrong, not when things go right, because then everybody is happy and nobody has any trouble. Now, if the purpose of a contract is to say what your obligations are, what your do's and don'ts are when things go wrong, then that's the first thing to do. Now, what I tell my clients always about a contract is I say to them, look, let's say for argument's sake you've got a very long contract and it's 50 pages and you reckon that it's going to take you 2 hours to read it. Print it out the night before. Go in your diary, book out that 2 hours. You get in the office in the morning, you take a cup of coffee, hopefully strong, drink it, and then relax, take a deep breath, and read the contract. Because if you don't read it, you will never know whether you actually agree to those terms. And if things go wrong, and you come to an attorney, and you say, but this and that, and I read the contract, and then I say, well, there's nothing that I can do because you've agreed to these terms. So you have to read the contract. Now, why it is so important in these events, you need to go and have a look and see whether there is a force majeure clause. And if so, what does it say?
Now, Jaco, the next question, what on earth is a force majeure event?
That's a very good question, because it's one of those terms that gets thrown around a lot. Some others refer to it as well as an act of God, and there's another term, vis major, which they also refer to. Now, in simple terms, that event it's an event which occurs due to no fault of any of the parties, and neither parties could foresee that event. So it's nobody's fault. So if there's a flood, hence why they also refer to it the term of an act of God, isn't the tenant's fault, neither is the flood the landlord's fault, or the pandemic for that matter, is the same principle.
Yeah.
So now, contract, if we go back, remember we said that the contract is the law between the two parties. So now the parties agree beforehand to say, well, okay, if 1, 2, and 3, and 4 happens, you will be excused from your obligations, i.e. paying rent or that sort of thing. And certain contracts specifically cater, and we've seen it now also in this, the irony of a contract and drafting a contract is you only know whether your contract is drafted well, i.e. if you're now the attorney, once it gets tested. Now, force majeure events in South Africa, the last couple of years, we've been tested on those clauses over and over again, because we've had then we had the riots in South, now we've got the floods again.
Yep.
Thankfully, my contracts have held up, but it's one of those things that you drafted, unless it's tested, you don't know whether or not the case. Now, coming back to it, so certain contracts actually refers to government regulations published, because one needs to remember that in this instance, in the majority of instances, the losses that people suffer suffered and still continue to suffer isn't necessarily as a result of the pandemic. It's as a result of the regulations that stopped everything. So therefore, the words in the contract of what constitutes a force majeure event is very important. So I look at a lot of commercial lease agreements for my clients, and a lot of them have a clause in there that to say that the obligation of the tenant to pay its rent is there and you always have to pay it. Then they say, except in instances of force majeure as defined under clause 5, for argument's sake. Now, if in that clause 5, the government regulations isn't stipulated in there, the argument is from the landlord side to say, but we agreed that unless there is a flood that totally destroys your property, you have to pay me my rent. So now you've agreed to a term like that. Now to go afterwards and say, well, this isn't right, we can't do this, you won't be able to, because you've agreed beforehand. And on that, one has also to need to look at, and that comes back to those first questions that I posed to the listeners, is to say, from which point of view you are looking. Are you looking from a landlord's point of view, or the tenant's point of view? But I'll catch on that a bit later. So yeah, you need to make sure or read your contract and then see if there is a force majeure event included in it.
And what if it's not included in the contract, Jaco? What then?
So then the common law comes into being. Now, in South Africa, the common law and supervening impossibility. So now, again, it's strange terms, so let me explain that. So in South Africa, we basically have two sets of overarching laws, if you can put it like that. The one is in written form, where there's a physical piece of paper, which is statutory legislation that's written, like the Consumer Protection Act, the Companies Act, the Disaster Management Act, like in this instance. So if you need to know what your rights are and what you can and you can't do, then you go and read that specific act. But that's not the only type of legislation we've got or laws that we've got. We've got the common law. Now, the common law came about since the Roman law and then the Roman Dutch law, and then we had some influence in the English law, and subsequently those things were written down by scholars and through court cases. For argument's sake, theft is what they call a common law offense. So you won't find an act that says you may not steal. And what is the definition of theft? You have to go look through the case law to determine what that law is, which of course makes it a bit tricky to know what your rights and obligations are, because the man on the street won't know the common law. Certain things will be common sense, like theft, now, and others won't be. And this is where the supervening impossibility comes in. So supervening impossibility is a common law principle. And in essence, what that says is that when performance of the contract is objectively speaking impossible, so let me put it in a less lawyery fashion. So if the landlord can't provide you the property to use and you can't pay the rent because you're not doing any business. So for argument's sake, the flood is there. And now it's totally destroyed. So neither party can perform the contract because objectively speaking, it's impossible. Then this principle comes in and say, well, it was no fault of either of the parties, and therefore you can now cancel the contract. But now you have to say that the test is objectively speaking. The test is not to say whether I'm making less money or now suddenly it costs me more. Take another example, the electricity situation that we are in. So now Eskom fails to provide electricity or government shuts off. It's neither party's fault, but that doesn't necessarily mean that you're not able to make another plan. Let's take a restaurant when only takeaways was allowed. So yes, it's going to cost him more because he now needs to do other things than he normally would have the restaurant to operate, but he can still operate. He's making less money, but he can still operate. And then in that instance, it's not objectively speaking impossible, and hence you won't be able to rely on it. Now, coming to or elaborating rather on the example that I said with a restaurant and selling things as a takeaway. When I was still at law school, we had a case where we had the guy was a vegetable vendor who he was selling vegetables out of his bakkie. And another gentleman came and he drove into the bakkie and the bakkie was written off. So what this vegetable vendor did was he went out and he rented another bakkie so that he could continue selling his vegetables. Now, he then sued the driver of the other vehicle for the loss of his first bakkie, and he sued him for the rent. Now, the driver of the vehicle was upset, and he said, but he can't be expected to pay the rent of the bakkie. And what the court said was the fact that vendor rented a bakkie meant that he took into his own hands, he took on the responsibility to minimize his own loss. And If he hadn't minimized his own loss, his loss would have been greater because, of course, he wouldn't make profit out of selling the vegetables. Therefore, the court said he's entitled to that recovery. Now, had that vegetable vendor decided, oh, well, now there's nothing for me to do, I'm suing this guy for the price of my bakkie and my loss of profit for the next 2-3 years because now I can do nothing, then the court would have said no. But there wasn't literally nothing that you could do. You have a responsibility to minimize your loss. And if you don't, you run the risk of the court saying, well, because you haven't minimized your loss, you're not entitled to the full amount of money.
Well, that's very, very interesting, Jaco. The next question is, obviously the Disaster Management Act. That's something we've heard of so much in the news over the past few months, especially state of disaster as well. But the Disaster Management Act and its regulations, is there a direct impact on whether or not the tenant has to pay rent?
Yes, yeah, no, definitely. And because the regulations, they limited or prohibited only certain activities. Now, on that again, so there was a hard lockdown, and let's say for argument's sake, a computer company, which was also, let's just use it as an example. So these software developers rented a property. Now, as a result of that hard lockdown, they weren't able to operate within that premises because they couldn't physically drive to it. But what they realized afterwards was that, well, they could actually operate from home. They don't need a business. Now, their lease was correct and written right in the sense that the force majeure clause said that if, as an act of government, you're not able to, for that period, we'll give you a rental rebate. So he received the rental rebate. But then he went further and said, now, as a result of all of this that happened, he now can no longer pay rent, and he had to retrench certain individuals and that sort of thing. In that instance, it will be arbitration, because normally your leases has an arbitration clause in it, but that we can get to on another day. There it was found that the reason for him no longer renting it isn't as a result of that limited period of hard lockdown. It is as a result of him realizing that it's more cost effective to operate from home and that he doesn't actually have need an office. And hence he was still obliged to pay that rent. Now you've got other instances where you have specific services which are allowed. Let's say, for argument's sake, your security companies that went into stage 2, well, they were there from stage 1, or petrol stations continue stage 2 in those certain instances. Now, if your specific area did not or fell within those services that you were allowed to do, then again, even if you have a force majeure event or clause, then rather, even if you have a force majeure clause that covers you, then you won't be able to rely on that. And similarly, you won't be able to rely on supervening impossibility because it didn't make specific provision for that. But now, as we stand, the Disaster Management Act has now, of course, been repealed, and none of those regulations are any longer applicable.
Wow, okay. Jaco, are you ready for the very big question now?
I hope so.
Can a landlord evict families from their homes? We're going to talk about the municipality just now and the electricity, but can a landlord evict families from their homes? And if so, when can he or she do it?
Okay, so that has changed quite a bit throughout the lockdown and with the lockdown regulation. So firstly, a landlord can't evict a tenant without a court order, even if the contract has expired. So you've got a contract for a year, and thereafter, Mr. Tenant, you and your family needs to move out. But for whatever reason, that family decides that they are not going to move out. The landlord isn't allowed just to go and lock their their doors or shut off the electricity or physically remove them, you have to go through the courts and have to go through a process in order to do that. Another example would be, so the first thing that needs to be established is to say whether or not the tenant, the family in this instance, still has a right to occupy the property. So if you don't pay your rent, let's say for instance, this instance is that now as a result of the husband losing a job due to COVID, now he can't pay rent. Then the landlord first has to place that tenant on terms, which means that they need to write him a letter and say, I see you haven't paid your rent. I give you, for argument's sake, 10 days to pay the rent. If you then fail to pay the rent, then you will no longer be allowed to occupy that home. So now the letter is written, 10 days given, the family hasn't paid. So now that family no longer has that right to occupy the premises. But now with the Disaster Management Act and its regulations, what then said is that nobody is allowed to evict a family from their home. So even though they haven't paid rent, and even though they therefore no longer have the right to be in that property, the landlord can go to court to apply for an eviction order, but that eviction order may not be executed. Then what happened is that after the second stage, you had a less stringent process or hurdle to overcome from a landlord's point of view. So, well, you can get the eviction order, but there's certain requirements that needs to be met. So it was a very, very lengthy process. So in that instance, the government did come and assist families to say, well, look, you are there, you can't pay it, but they can't evict you. Now, of course, that's from the family's point of view. If you now look again from the landlord's point of view, it's terrible because he needs to pay the bond. And if he doesn't pay the bond, then the bank will let him default on it. Or some of the banks did. They said, well, we'll give you a loan at X amount of interest. But again, that needs to be covered. The reality is like, in a situation like this, there is no winner, no matter what. You just have losers at the end of the day.
Yeah. Yeah, that's very, very true. And Jaco, what if a tenant gives the landlord 50% rent or 80% rent? What happens in that case?
Yeah, so first of all, the tenant will still be in breach of his agreement. That's the reality. But now the big question comes is to say that when applying for that eviction and the tenant has now paid 80% of rent, the judge at the end of the day still has to approve that order to say evicting him. And that's in the judge's discretion. So the judge can say, but hang on. So we're sitting with a situation where the tenant has paid you 80% of the rent. You know that the chances of them being able to find another home in this situation might not be very good. And now still you want to proceed with the eviction. So depending on the judge of the day, he or she might either be very strict or they might tend to lean a bit more to be more lenient in the instances. To say, well, okay, how do we move forward to that? But strictly speaking, if the contract says you have to pay 100 Rand and there isn't specific force majeure events in the contract that covers for it, again, why the contract is so important, and you don't pay 100 Rand, then you're in breach. It's like they say there's no such thing as a big sin and a small sin. Now, a contract is almost the same and say there's not a big or a small breach. That's not 100% correct because certain breaches goes to the root of the contract. And if you breach those, then you can terminate. Whereas, let's say for argument's sake, the contract says you have to change a light bulb, but now you don't change the light bulb. And the contract doesn't specifically say you're entitled to cancel the contract, then you can't change cancel the contract because it doesn't go to the root of the contract. But paying rent or not paying it and the amount, that goes to the root of the contract because, I mean, that's in essence, that's what it is. It's like the tenant has to pay rent and the landlord has to provide him a property. those two things are the major ones.
And then the last question, Jaco, is can the municipality come and just shut off your electricity for non-payment?
So let me just tell you this story. So we received a email in one of the stages of lockdown from a lady that quoted us legislation to say that that the municipality is not allowed to disconnect the electricity. Now, I looked at it at first glance and I thought, I missed something terrible. I don't know what happened. And then I scrolled down in an email and I saw she quoted a extract of Indian law, not South African law. So people need to be very careful about Google and what Google says. So this lady obviously just Googled, can they disconnect your electricity? And I don't know how the search engine is set up, but it came about something from India. So
Yeah.
Well, unfortunately, this is South Africa and not India. So there were some municipalities during lockdown that made sort of publications, if you like, or in the media to say that they wouldn't shut off electricity. But there was no specific prohibiting legislation or factors or regulations which prohibited a municipality from disconnecting somebody's electricity. So again, in this instance, the municipality needs to follow certain rules. So a municipality can't just do whatever they want to do. And they, of course, need to, again, recover the usage of the electricity. So if they follow the right processes, giving you the necessary notices, then in that instance, they are allowed to disconnect your electricity. But make sure that there is notices, and if you have a valid dispute, what you have to do is that lay a complaint at the municipality to say you're not allowed to disconnect because I have a dispute. Then they can't.
Very interesting, and if they don't switch off your electricity, Eskom will definitely do it for you with the load shedding. Oh my gosh, interesting. Jaco, I hope that we answered most of our listeners' questions today. Thank you so much for your time. How do we get in touch with you?
Yeah, you can go on to our website. My contact details is there. If you click on my profile, you'll see my email address there, or we've got the generic email, but I can give you my email address is Jaco, Jaco, @hahnlaw.co.za.
And that's HAHN, Hahn Hahn Attorneys. Jaco, thank you so much once again, and until next time.
Thank you, and thanks for the opportunity. Enjoy your day.